Okay, good morning, everyone. How are you keeping? You okay? Good. Okay, sorry if yesterday was a very background noise. I wasn't at my own place, so that's the reason we not deliver. But I'll go through LO1 today instead of LO2, and then we carry on. We can change that slightly, our delivery pattern. So we'll go through LO1 today, and next lesson we'll go through LO2. Okay, let's please we introduce ourselves. I think so. I'm not sure. Have we met before? I deliver you any other subject? Yes. Do you know me? Okay, I'll introduce myself and then we'll start. Okay, give me 1 minute. Okay, so how's weather your end? Here in Leeds is cloudy. We had a yesterday heavy rain, and I'm not sure your end how's weather there. Okay, let's please. Give me 1 minute. I'm just trying to log in. So please, do you have a Moodle access? Please, can you log in on Moodle? We'll go through the unit specification first, and then we'll go through our LO1 today. Okay. Sorry, I'm trying to log in and quickly we'll go through. Oh, come on, okay, I'll share with you all the handout first. Okay. Okay, welcome. Good morning, everyone. We'll start our lesson one. Today lesson will go through LO1, which is understand the element of law affecting commercial practices and practice, which we look today are LO1. Unit is, of course, we are looking extended diploma in accounting element, IFA Direct, and we have, good few learning outcome, which is 4 learning outcome. We'll go each lesson 1 learning outcome. So today, key our learning outcome is learning outcome 1. I'll go through the unit specification and I look, all these learning outcome during each lesson 1 learning outcome, which we'll go through. Okay. A couple of you, of course, already know about the law, of course, day in and out, either we work, we member in practice, we carry on dealing with a lot of contracts. So that's the key, and the contract come under the civil law. Okay, that will be the key which we look, today lesson. Okay. As a couple of you know me, my name is Anjum Sattar. I'm working with the university last 10 years, and I'm also teaching at University Bradford, and I do some work for lead. I'll try, and I'm also member in practice. and I'll try my best, to meet your expectation. And please, during our delivery, if you have any question, feel free ask, so we can collectively learn together. And that's the key, which we'll go through. Accounting, what is accounting? Accounting means systematic record of business transaction in account, and the rules really we need to follow. And understand the element law affecting the commercial practice. There are the various law, those affect, the commercial practice. So those we need to be go through, and which we'll look, in details today. Please, if you have any question during our delivery, you can drop me email anjum@ukversity.co.uk. So please, I'll try my best to get back to you as soon as possible. So this is my email address. So that's all about me. So please, if you don't mind to quick you introduce me, where you're from, are you in member in practice? Yes. So we can include, examples accordingly, please, if you don't mind to. Yes, Abdul, where you from? What you do, please, if you don't mind to. If you can't speak on the mic, but you can chat in the chat box. Huh? Oh, from London. Okay. How's weather in London today, this morning? Okay. Yes, please. Who else there? It's good morning, Rana. Like here, are big difference. Okay. Let's please. Who else there? Good morning. Sila, please. Where are you from? Okay. Good morning. Yes, if you can hear us, so you can maybe chat in the chat box. Okay, good. Oh, from London too. Okay, great. Thank you. Thanks for sharing. Let's, we'll start. Okay. Sorry for yesterday. The aim of this module is to develop the understanding how the English law impact, business organization, your member in practice, especially professional accounting practice. And that's why it's quite crucial. We need to be look around. So current your knowledge about the contract law, please. Scale 1 to 10, how much we know about the contract law. So that's here really we need to be look around. Okay. So please, we'll go through the contract law, which is element a valid contract. What are those elements? We look around the agencies, the relationship between agent, like a director of the company, and then shareholder, actually owner of, director can be agent in the public limited company. And we'll look, some relevant law. We'll go through the tort law, negligence, and what sort of the damages can be in the negligence, and the case law. All will be in our discussion. Of course, I'll give you share with you the book. Okay, if you want to please set up your account, is the good morning everyone. We can look around ACCA F4 exam, which is about law for accounting. And then please, if you want, the website is Open Tuition. That can be, it's a free account if you want to, or other than it's good to be look around the article F4 ACCA exam. That's, it's quite good to explore. And other than that, I'll share with you Osborne, Kaplan, BPP, and various other books. Those will also help you, and we can enhance our understanding about the contract. Contract is a component of the law or obligation itself, an element of the civil law. Civil law is the law. If you don't follow it, you have to pay the damages. But the criminal law is more, if you don't follow the legislation, is a crime. So is actually the civil law is quite crucial, is binding, protecting both parties, their interest. If you agree for the fees and where is the deficiency in the service, and the other party is entitled to claim the damages from. Welcome. Good morning, Farouk. Okay, can you hear me?
Okay. Yeah, I can hear you. Good morning. Yeah, sorry, I was just a bit late.
We just started. You're just in time, GIT.
Wonderful.
Okay, so what will the key element in any contract really is offered? There should be acceptance and is the agreement and consideration. In contract need to be sound mind. sound mind mean if your contract is written in English and actually the people can't understand the language, we can say is a disability not mean physical disability. They can't understand, so it's not a violent contract. Yes, so because there is a offer and acceptance now. Okay, other issue is the contract should be written. No, the new last contract can be verbal contract. If you're discussing anything over the phone or you agree thing, it can be become a contract. Yes, so that's and then of course it's civil law. This come contract under civil law, and it can be damages, and we can have to pay some remedies. So those we need to be looking at the law. So what is the difference between criminal law, or we call public law, and the civil law we took known as a private law? So constitutional, administrative, and criminal, that's all treated under the public law, and the private is the contract law, tort law, property, trust, and family issues, and that's all come under the civil matters. It's not a crime. Yes, it's not come under the criminal. Okay, so contract is the simplest definition, is a promise to enforce by law. The promise may be something or refrain from doing something. So making the contract, they require the mutual really contract mutual consideration between two parties, and ordinary we can. These are the key elements. So please, when we in a commercial world, when we looking the contract, we have to look around. There should be in the contract, there should be offer, there should be acceptance, and there we have to look around the intention. So contract is an agreement, offer, and acceptance. There should be intention, legal binding, and there should be certain. If we are not sure we will be able to deliver, that's not really. Certainty is quite crucial as well. Capacity, they have a capacity to understand. They are sound mind. We're not dealing with the underage. Those I can't be in a contract. They can't enter because that's they don't have a capacity there. Okay, then we can look around the consideration. So these are 7 essential elements: employment contract, lease agreement, insurance contract, all these. That's why the contract law is quite crucial, which we have to look around. Okay, so contract law aim is to provide effective legal framework contracting parties. We have to look around. Like on over the phone, if you're doing contract and other party saying, no, I'm not interested. If you recorded that under the SAR, it's called subject access request. You have a right to ask, give me the copy of if any call recorded, if any mobile contract or any other contract. SAR is called subject access request under the Data Protection Act 2018 GDPR, General Data Protection Regulation. Either you want client record from HMRC, from Home Office, immigration file, or medical file, you have right to ask yourself, or if you client give you a 30, normally fees is a £10, and a lot of company they don't charge even, and thus you can get all the record whatever they hold about the individual. So that's or you can ask HMRC as well, or maybe the client asks you, give me all the record what you hold about me. So that's why the record keeping under the contract, which we need to be look around as well. So please, if any question you have, you can ask. So agreement and the legal definition. Agreement is the meeting the mind or the mutual understanding between one or more person about reciprocal rights and duties regarding the past or the future performance. Of course, performance and the contract. Okay, there is other issues. Please always remember, if you posting a letters to HMRC, the posted date is the date when you really, you action your contract. Yes, the date of postage. So that can be argued in the courts. Yes, so that's the key. The date of postage is count a lot. So contract is the specific type of agreement that in term are the element and the legal binding and enforced in court. So that's which we need to be look around. Okay, example of the standard contract can be unilateral. The contract is agreement in offers and the acceptance are the two parties. Yes, and we can look around the insurance policy contract, which usually partially unilateral. Yes, bilateral, also called clearing trade side of deals, and refer an agreement between the parties and the stated aim to keep the trade deficit, that's which we can look around in the agreement. And the type of the agreement can be unilateral and bilateral, and take some time to finalize. So when we can summarize these into these two key, all parties assume obligation under the contract. Bilateral mean all the parties assume they are binding under the contract. Unilateral, only one party assume the obligation under the contract. Only one party assume under the contract. Like the council, they should assume, and other parties should be. So that's the council is responsible of various things. So we can look around these, different contracts in a minute. Of course, we can argue on these. Can be. Okay, so an arrangement usually informed between two or more parties that is not enforced by law, and the contract is agreement which is between two or more parties in term of an element is enforced by law. So anything enforced by law is it can be come under the contract. So involved in parties, we can look around unilateral and bilateral difference. One party is obliged to honor the agreement, and two parties legally accountable to honor the agreement. So farm, there are reward in unilateral contract, and there is a no reward bilateral contract. So we can look around the time frame. There are no strict, the time frame under the unilateral. In the factory, the promoters may extend the time, like sales contract is offered to treat, not is acceptance. We put the prices in advertising, but the price is being withdrawn, and you're saying no. That's the unilateral from one side. And there are the deadline, but because we not agree on the price, there are the deadline in the bilateral contract which are agreed upon the start of the contract. Okay, so activeness, which we can look around, no active until they promise to deliver, and active upon really signing the contract. When you sign it, it can be. So that's the key difference between these. Okay, and please, anyone, if any question, you carry on asking. Even you can. Okay, thank you. Okay. Unilateral and bilateral, which we just mentioned. Yes. Let's say we are advertising, you're selling goods, you advertise it, and you're saying this is the offer for a certain period of time, because you're offering, other party not accept it, is your offer in the market. That's is an open offer. That can be a part of unilateral. And the bilateral, when we are agree on that price, you will deliver the goods and we sign it, and that become a bilateral contract. Yes, unilateral is towards your one-sided, and the bilateral when both parties are agree to be delivered the things on the certain price, on the certain term and condition. So that's the bilateral. Then instead of, so like here, not action until promoter deliver or the promise deliver. Yes, and active upon the signing the agreement. When you sign it, it's becoming your contract, and that's which will need to be whatever the term and condition we agree. So there can be in the contract can be express term and the implied term. Like if you look the employment contract, express term, which we are expressing in implied term by law implied, like you have to data protection, you have to follow health and safety, you have to follow, and these can be in an employment contract. Hope this will help. Okay, then we can look around the offer, which we can look further examples as well. Okay, offer and acceptance and agreement, which we just mentioned earlier. Invitation to treat, that's which we look the keyword in the contract. Termination, of course, when we fulfill the contract, it can be automatically terminate, and the consideration we can look around either sufficient existing duties or the part payment. That's all. We presume intention to be bound, and we can look around the type of the condition guarantees. We can look around in the law as well, like electric product, when you buy it, 3 months, Those are 28 days rule, but we need to be look around in the law that's for particular certain things. The damages, the common laws, the compensation, not, uh, it's a punishment really. We can look around the performance and injections. Okay, the law of the contract has been developed, over the years of the decision. The judges regulate how the business should be done, and it's help reduce the conflict. So contract, it's no harm. Are always better to be pleased if you have the letter of authority, the contract between, because sometimes maybe client expect you're offering these services, then and we saying, come on, we'll do only return for you at the end of the year, and this will be the fee. So please, that's, it's better to be ticket and give the sign of the party, because that become a legal binding. Of course we can do verbally, but how we can prove in the court, that's, sometimes the problem can be a privacy of the contract, exactly who are intellectual obligation of to. So GDPR, please, we both, are, they don't need to tell. If they tell third party themselves, it's not our fault, but we as accountants, if member in practice, so we have to be look around. Might a contract be void or voidable, which we look, it's been not acceptance, not be are being changed, so it can be various scenario which we look, free from the contractual obligation. So please, there are a couple of videos about contract. It's good to be watching your, those are given. I can copy the link, but I'll give you. Okay, let's, we move to with the following lesson. We'll go through as well good few examples that will enhance our understanding about the contract. And the contract is very, very important. It can be many problems we have, especially member in practice. So it's good to be protecting our interests. It's good to be written like, the authority letters, sign, the consent, the contract, the surveys, the fees, obligation, 5 professional code of ethics, all we can look around in those perspective. Okay, let's please 1.2 explain the principle of agency and their impact on the business. Agency. So there are agency theories, and the agency theory is a part of the bigger topic of the corporate governance. Who is the agent? Who is the corporate governance? Mean how the company run and control in our organization, and especially back in 2014 when the Barclay Bank not earned the single penny profit, and the CEO being paid, £2 million bonus. So we have to look around why. So especially Theresa May changed a lot of, their work on legislation and the corporate governance back in 2012 onwards. Yes, so we have to look around these uh, issues. Actually, the agent is the shareholder, actually the principal, and agent can be director in the public limited company. The relationship between them to work on the behalf of is called the agency relationship, and there is agency cost of it. It can be their behavior, their trust, their faith on the agent. Like we can be agent on the behalf of the our client. Actually the client is owner of the account. If the client not give you the evidence to submit to HMR, a client is telling you the figures and you rely on, but technically we're supposed to be get the evidence like a bank statement, and then we do the return. So we have to be look around these perspective all, so agent is accountable to the principal, not so we are accountable to what. Yes, so HMRC can ask us as a professionally member of it, but otherwise we can think about, okay, like in the same way we are tax collector, we are agent on the behalf of HMRC, I have VAT to submit them. So that's, other issues we need to be look around. Agency theory can be applied in agency relationship, driving from the separation between the ownership and control. Yes, who control it, who own it. So there can be like stock exchange. Their relationship also we call free responsibility to the shareholder, the principal, and they have the voting right. They can change the agent through the voting right. Of course, the agent shareholder normally pay the possessive role in day-to-day management, and the companies, of course, less than 1% of the shares, mostly under the large companies only 10 director and listed on. So that can be in public limited company, can be many directors, but we have to look around who's, and then board of directors, of course, agenda objectives such as the desire of the high salary and the larger bonus. Of course, we can we get the contingency fees? We can say to client, if I'll save your tax, you pay me half. Let's say their tax is 3,000. We are saying them, if we save your tax, you pay 1,500 and you pay me 750 pound my fees. Can we say it? What do you think? Of course, you already know, but just want to do a bit discussion. Yes, what do you think? Can we say to client? Because I'm saving your tax, you give me from the saving half of the fees. What do you think?
Yes, you can, I think, because it's a contract if you between each other. If everyone agree, then it's fine, I guess.
No, please, because the reason, even is a contract by law, contingent fees, yes, contingent fees never charged with the condition of it, yes, as accountant. We charge, yes, you can say, because to matter to solve this, it will be spent 10 hours, yes. My rate is 7, let's say 70 pounds, yes, and 700 pounds, yes.
Yeah.
Instead of you write, I will charge half of it of your tax saving.
Okay, the wording matters.
Yes, so we never charge the contingent fees, condition with it, yes.
Yeah, okay, not with the contingent, okay.
But you can charge, you can estimate how many hours will be required to deal home office. Your matters will be sought out and we charge the fees for it. Not the condition for it, yes.
Okay, yeah, got it.
That can go against. Okay. Of course, you registered now with the IFA, yes, as a student, and they good to, because we have a lot of sessions CPD. If you're not, you can find it. Yes, Google it. I can send you the link. And these CPD sessions, okay, it's not only in the UK CPD session, so you can use it UAE. You can look around the Saudi. You can look around Australia. Yes, and even another part of the world. So that's which we can look around. There a lot of other legislation on these as well. It's good to be for the corporate governance if you're dealing depends on your clients. Okay, so agency theory help you to explain the action and the various interest group in the corporate governance. So like that we have to really, there are the two theories now. In the past we used to be called shareholders wealth maximization. Yes, shareholders. Now we looking the stakeholders. Yes, we have to look around everybody's interest. Yes, stakeholders interest, not just the shareholder. So you have to be look around as agent, transparent in information and as much we can in. And of course we have to not only work the shareholders now, but we have to keep in mind, yes, because we are agent in the legal binding. Okay, principal agent relationship, the separation from the ownership and control. Yeah, so when you are, even you have the share, your owner, but the control and a conflict of interest, sometimes it can be. So we reduce those conflicts by clear writing and segregation of duties. Yes, it will go through in the internal control as well when we'll go through the following lesson. So we can look around a lot of corporate governance rules. We have the Cadbury report. We have various other reports, green reports, Hamel reports. These are all corporate governance. How you go on that. Okay. Yes, please. Any question if you have, we can, but we move to now on the next one. If you no question, don't like to ask. Okay, so 1.3, explain the law of the tort and remedies. Yes. So remedies like PPI. What is a PPI? What was the PPI? Do we know PPI? Of course, we maybe heard or maybe you not deal with it. Yeah, depends. Yeah? Because it's a payment protection insurance. Yes, that's huge payment protection insurance happen in the past. So we have to be think about the payment protection insurance, and that's it's a lot of those company offering that service. GDPR, they collecting the data on the behalf of their consent. They getting SAR. then they finding they paid PPI in the past, in the cards or various things, and they can claim their money from the bank or various financial institutions. Of course, the lot of those service providers, they keeping up to 40% of the fees. Okay, so that's the tort is the type of the civil wrong. It is a breach of the legal duty. So that's why, please, we have a professional indemnity insurance to be registered with the IFA or any other awarding body. So we have to the professional bodies. So the damages, the tort is the breach of the legal duty. So it's our legal duty to check the things are in right, those are in true and fair. So please, our legal duty is the 5 professional code of ethics, PPCIO. What is a PPCIO? Popular people chat. These are, to remember easily, you can say popular people chat. First thing is a professional behavior, not back end commission we are getting. Yes, we provide the service and we charge true and fair, and we give the true and fair views about the financial statement. Second is the professional competency due care. Yes, that's up to date knowledge, and we do the CPD. C is confidentiality, I is integrity, honest, and O is the objectivity. Yes, that's not conflicting information. Our objective to be true and fair information to pass in the law. So if the tort is a breach of the legal duty and there is a no liability unless the law recognize the duties exist. Yeah? So difference between the contract and the contractual relationship does not have the established for the claim in the tort to be successful. So we have to often the parties have the never even met before. For example, the claim for the personal injury, they never met as the result of the road accident. The parties will often have had no previous relationship at all. They not entered into the contract, but if somebody if they have a duty to pay to other to damages, or it can be under the insurance. Tort has been committed and claimant may be choose the remedies most appropriate. Yes, most appropriate. That's there are the two options under the valid contract. The amount of the damages, yes, awarded intended to put the claimant back into the position. If your, let's say, accountant not submit the return on time and the client paid the penalties to home office, HMRC, so whose fault? So yes, maybe if you ask them, they provide the paperwork, they didn't, so you have the record for it. They not provide the letters, so it's better to be send them email instead of calling them. If you don't have a call log, I'll record it. I call at such and such time. Client not gave me paper. I can't submit this return on time. Yes, is it then? It's mean protecting ourselves, our interest, and as well as the client. So the tort is the amount of the damages awarded is intended to put the claimant position that would have been had if the incident not happened. Yes, like accident. So tort or negligence is the contract or the limitation period of 6 years from the breach of the contract. Tort is the limitation period is generally 6 years, but 3 years for personal injuries. So that's which we can look around the main element of the tort. In order to successful inaction of the tort, the following conditions they must be act or the omission by defendant, and we can look around the act omissions have directly cause of the loss to the claimant. The court must be able to establish the legal liability as the result of the damages must be as direct consequences of something. So that's lot of these injury claims and all of this. Nuisance, the tort nuisance allow the claimant to sue the most act interest with their use and enjoyment of their land. So if that's or the nuisance or the public nuisance, the private nuisance, the law recognize the landowner as the choose the rightful possession of the land, have the right to be reasonable comfort, and if you disturbing them or their comfort, that can be tort and the damages can go to other parties. Yeah, they interfere in my. Okay, so that's under the criminal law, public nuisance is the class of the common law, and the offense in the injury that the loss of the damages the local community, and lot of claims against the councils as well can be included. Manufacturers who polluted stream and the keeping a diseased animal and shouting firework in street. Yes, that's these we can look around. Trespass of the land, which we can look around these laws. Personally, directly enter upon other land without their permission or remain upon the land, places or projects, any object. So that's like you putting the advertising as well. Yes. Generally, trespass is the person consists of the three: assault, battery, and false. So battery is the in law we use the term. So the tort is intentionally and voluntary bringing about unconsent, harmful, or offensive contact with a person, and they must be actual contact. And assault is the intentionally act to putting an individual in a reasonable fear. Oh, if you don't give me, I will tell to HMRC and this. Of course, we have a contract. We look at yes, assault it. So there does not need to be actually battery, and therefore they're not necessary any contract. Fall imprisonment, if there is a person unlawfully arrested, imprisoned, or prevent from leaving where they are, and negligence that can be damages goes to. Okay, negligence is a breach of the legal duty of care. So duty of care, yes, we have the duty of care to clients. We have the duty of care to, as public, and in the public and wider interest of the society that can be wide all the legislation as well. Duty of care to owned by him and defendant. So who is in the duty of care? Yes, the duty of care to take reasonable care and not the cause of foreseeable harm others. Okay. The neighborhood principle. So please, we included some case laws here. So please, it's good to be look around. Like we have one of the case law was the first established the duty of care, who is owed to person or everyone in the neighborhood. Yes. So prior this case, believe was allowed the action and taken, and where there was a no contractual relationship would be undermined. The principle of the contract law, the trade, the we can state the only party to contract the sue or be sued. So in the chain, in the principle and result is the manufacturers of the good of the duty of care to the ultimate consumer of the product. Yes, that's one of. So there are the couple of case laws please in this when neighbors principle avoid the goods. So in we have the Sales Good Act 1979, Sales Good Act 1979. Good need to be fit for purpose. If not, other party have the right to claim the damages. Yeah. So that's you have a right to return the goods if not fit for purpose. So there are these. It's good to look around in some cases in which we can contextualize. We could look in the following lessons. We included some of the case laws, please. So given contract, there are the contract of offer and acceptance. So I'll share with you, because when we'll do our merit and distinction criteria, when we'll do assignment, we'll look these in. So our D distinction criteria, please, in this our LO1 shares and the details shareholders and editors, they have editors is shareholders, the owner, and editors is have the contractually and corporate governance, and the editors should give the true and fair views about the financial statement in line with, and we can look around the cost of agency relationship, how much money we paying, and what service we accept from the shareholders. Sorry, from the editors. So editors is should be complies with, like we have the company called Enron. Couple of and the residual losses, if anyone, and so that's which we can look around. Yes, there are the agreement of AGM. AGM is the annual general meeting, and where we can look around the shareholders. I have the right to give the vote, and through voting, of course, selecting, and especially common. There are two types of the shares, nominal and preference. So nominal ordinary shareholders, nominal is the value. Ordinary shareholders have the right to vote, and the preference not. Preference only preference on their profit. So we have to look around those parameters, and there are a lot of code of conduct is published by OECD, which is called Organization Economics Cooperation Development. ACCA code of conduct, if you're a member, IFA code of conduct as an accounting technician, as accountant, and please, I included the link for you to do a quiz. You can set up the account as a Kahoot and you can go through, but which we look, these in. Okay. Yes, please. I included the element of the contract. You can copy the link. You can look here some and watch some videos and go through some example of the contract law. Or other than that, please, uh, quickly show you Open Tuition. And I'm not sure you ever used before, but it's good too. Okay. So if you go please here ACCA, and you can set up absolutely free account if you want to. So go here and then please be looking law is. So that's which we can look around. So please you can register yourself. You can download the free yes, corporate and business law, the title of it. So please you can click. You can, of course, we are looking more about English laws. Yes, the contract, and so you can click there. You can download full booklet, and then other than that, I'm sharing with you now other. So these, of course, you don't have exam. We can look around the contract. Yes, contract law. So you will see here the chapter. Yes, if you want other laws, all the company laws and all, but we looking more contract law from it. Okay, so I'm going to share in the chat box with you your books. Please, you can download and which we can enhance our understanding about things. I'll carry on embedding those, so that's quite to look here. So please in the chat box, yes, I shared with you the books here one. You can download all available on the Moodle as well if you're struggling from here. So please, and there is the Elliot 7 edition contract law book. That's quite good if you want to look around some case laws, different scenarios can be. Okay, then I'll share with you the 4 books of ACCA, of BPP and Kaplan. Okay, so for English law, I can send you the books. Okay, with so that's please if you want to pick, when we write, we can reference these and we can write from these books too. Okay, any question from anyone? Okay, so today we discuss about 7 elements of contract. We said offer, acceptance, consideration, legal binding, intention is very important, and in a contract. Then we discuss about agents and agency theory. Agent is the account details can be agent, and the shareholders can be principal, and they have the relationship, agency relationship between them, and the fiduciary relationship. They have to fulfill the best interest of the share and the wider interest of the stakeholders. Then we discuss about the tort, which is, the obligation can arise before we're not in a contract, but the obligation can be arise like insurance, accident, car accident, or the public duties. And we discuss about the civil law and the private law, and the public law. Public law is more about the criminal matters, and we discuss about civil matters with the contract law come, and the tort come under the civil law, and the family and the company. and which we can further look, deep dive into other areas of it, and which will go through under LO2. Thanks for attending today's session, and hope I will speak to you during our next lesson when we'll go through.
I've got a little question if you don't mind me asking.
Yes, sure thing.
Now regarding the assessment, am I able to ask any questions regarding the assessment?
Yes, feel free. Yes.
All right. Okay. It says somewhere down the line, you're supposed to write an introduction and also the conclusion. Okay.
Yes.
Now, when it comes to introduction, because there are several scenarios and we are supposed to answer all these questions based on the scenarios, how are we supposed to word our introduction? Like, what are we supposed to focus on the introduction?
Just a generic, you can say in this assignment, going to discuss about the contract and the civil law and the, yes,
Just mainly about the topics and write something about the topics.
the important in the legal world, yes, professional world is very important.
Okay.
You have to follow these, guidance.
Right. Not the scenarios. We are not going to mention about the scenarios or anything other on the introduction and the conclusion.
Yes, further you can, if you want to be, my assignment is based on the above scenarios given.
Right. Okay.
Then when you
and
question, then of course you can contextualize.
Right. And introduction is part of the word count as well?
Okay. Normally, introduction to reference, up to reference is part of your word count. If you have too many words, you can put in appendix. Any case law, you can snip it, you can put in the appendix, and you can say, please see appendix, that won't count in the word count.
Right. So if we use the case law inside the paragraphs what we are writing, then it's part of the word count? No.
It can be, but if you can snip them, yes, because maybe you're using as it is, and you can underneath, you can do the interpretation in the law. Then
Right.
your word won't be count. Yes, if is okay. Normally these words, please, word is only for guidance. If you have more words or less words, not matter.
Right. Okay. I'm just trying to restrict within the 4,500. That's what I was said. That's why.
It's a matter is you answer the question.
Right. Okay.
So not too much worried about word or so what we have sample.
Yeah. I've seen the sample. I've got one, but it doesn't have any introduction or conclusion on it. That's why I was considering.
You can write your end, which is good to be have it. Yes.
Right. Okay. But it doesn't matter if it is slightly above the word count, then there is no penalizing or anything of that sort.
I'm sharing with you, that will help you in the chat box. 3 files you can download. Yes, that's also help you. Okay.
Right. Okay. And the other thing is, you've just given us some books and stuff where we can use for references. Are we able to use like websites and stuff like in like gov.uk and Kaplan and all those stuff rather than just the books only?
Feel free, yes, because Kaplan is good. If you type the word contract and Kaplan, you can find the chapter of the book.
What about legal sites like legislations and everything? Can we use that as well? Yeah.
Absolutely fine, like you're using gov.uk or you're using any other Parliament. Yes.
Right. Okay. All right. And those all these references are supposed to come in from UK only, or can we use EU parts as well?
Yes, any part of. Yes.
Yeah. Okay. Great. Wonderful.
This is the area which can go. If you practice in different countries, can be law different. Yes.
Okay. All right. That's great.
No hard and fast rule. That's absolutely fine. No issue.
Right. Yeah. My word came to somewhere around 7,000. That's why I was considering.
No problem. What you can do, if it's too many, of course you can put even in appendix. Yes.
Yeah. Okay.
If you're using too many case laws, I think what you can do, have you used the snipping tool? In you snip them, yes, as it is, and you throw that won't count the word, because when you're putting anything in a picture, that won't increase your words, and that won't come the similarities. Underneath you can say as figure 1 or as yes,
right,
okay, yes, demonstrate, highlight, explain, whatever, right? So you can
right.
your.
Okay. All right. Thank you for that.
You're very welcome. Any other question?
No, that should be it.
Okay, brilliant. Thanks. And if any question, please, you can drop me, and we can even book one-to-one as well if need to.
How are we supposed to contact you? Do we have like?
Yes, I'm on the WhatsApp as well. We are in.
Oh, you're on the group as well. Okay, great.
Other than that, you have my email, Anjum.
You did reply to the message yesterday. I see. Yeah, it's you.
So you can send me and I'll go through it.
Right. Wonderful. And once I've done the assessment, can I just directly send it to you, or who do I send it for? Like kind of a
If you want,
read through it.
yes, if you want feedback before submission,
Mm-hmm.
you can
Mm-hmm.
send me my personal email. This one, yes, UK Versity one. And then other than that, you submit on learnerwork.co.uk. Yes, at
Okay.
UK.co.uk. Yeah?
I can send to you directly as well for feedback. Yeah.
Yes, you can send me. I can say, oh, come on, here are is anything need to change? We can amend it.
Yes.
Maybe put you some link. You can maybe I'll say, come on, this can be changed. Yes, this
Mm-hmm.
likely you can amend it. Depends. Yes, and then
All right.
I'll suggest you can submit on the learner work of central team will mark it, and they
Mm-hmm.
internally verify and sign up here.
Okay. All right. Wonderful. Thank you, Anju.
Thank you. Welcome. Okay, thank you. I'll speak to you next week. Have a lovely weekend. Thanks for attending.
All right. Bye-bye.
Thank you. Bye bye.